बड़ी ब्रेकिंग खबर लेकर आ रहे हैं, तो उसके पास सीधा चलते हैं। हाय अनीशा, गुड आफ्टरनून टू यू। दिस इज एज फार एज द सुप्रीम कोर्ट is concerned on WhatsApp. Supreme Court has said that they will not allow WhatsApp to share any India information with Meta. Give us more details. What's happening here? What is this case all about? And what is the big concern?
Well, Sakshi, these observations have come while the Supreme Court was hearing the petition filed by Meta and WhatsApp against the more than 127 crore penalty. Sorry, I beg your pardon, 237 crore penalty that had been imposed by the Competition Commission of India for market dominance and violation of and exploitation of market dominance. Now, WhatsApp and Meta have come to the Supreme Court against the CCI order, but the hearing went completely against them in a way, because the bench of Chief Justice Suryakant and Justice Joy Malia Bagchi have raised the issue of the way user data is being used and commercially exploited by these platforms. In fact, the Supreme Court has noted that will not allow you to share any information with Meta. Remember, the entire controversy connects to the sharing of data of users by WhatsApp with its parent company Meta. They had changed their privacy policy and given an opt-out option, but the Supreme Court has very clearly questioned who even understands your opt-out options in one, and two, even if the opt-out option exists, it only seems to indicate that the user can choose not to use that particular application or that particular offering from WhatsApp. So clear, very very clear comment coming in from the Supreme Court that you're making a mockery of privacy laws in the country. You've created a monopoly in the market. People don't understand your privacy policy, and the consequences of the policy are affecting the general common man of India. Now, what the court is questioning is not just the privacy violation, Sakshi. The court is questioning also how the metadata and the behavior analysis is being commercially exploited by creating targeted advertising for the users, by using the metadata of a user to create behavioral analysis of a group or a country or a particular area, and then that is commercially exploited by Meta. And the court, in fact, a very pointed question from the court, that unless you give us an undertaking that you will not share WhatsApp data with Meta or any other platform, we will not even hear your petition against the CCI order. So now this matter is going to be heard next week, as Meta has sought time to respond to all of these questions that have been raised by the court. But a very, very clear, pointed comment coming in from the Supreme Court and from the Solicitor General of India, that in Europe, Meta, WhatsApp, and other similar platforms have faced huge fines, huge penalties for monetization of user data, for monetization of behavioral analytics, and they have been asked to pay penalty. They have been also been subjected to tax uh, for this data usage. So both these aspects, whether it is user privacy, whether it is sharing of data, or whether it is the space that data occupies, the data rent and the monetization of data aspect, the Supreme Court wants clear answers on all of those, and it is very clear that it does not want to allow sharing of user data by WhatsApp or Facebook or any other Meta platform. In fact, questions were asked about market dominance, about the footprints of user data that was shared on Meta platform for targeted advertising. So a lot of questions have been asked, and the Supreme Court, and if you can give me 10 more seconds, I can also tell you that the Supreme Court of India has made a very important and interesting comment when it comes to this aspect of the law worldwide. In fact, the court has said that all over the world, the judiciaries will have to go into oversight, into the details of how these platforms are accessing, using, and monetizing user data. So it is a very, very important point that has been made by the Supreme Court of India today, and we'll see how exactly this moves when the central government, because this METI, that is the central government Information Technology Ministry has also been asked to respond on this issue. How does our DPDP, that is the Digital Data Privacy Act, interact with this aspect? How exactly does the Indian law regulate access to user, not just user
Got that.
information, or but also the data that a user shares on these platforms, because the user does not know how to opt out. The opt out option,
Absolutely. Right, Anisha,
all
we
of that
got
is
that.
now
So
being
basically, the
active.
Supreme Court has clearly come out and told WhatsApp at this point in time that they are not going to be allowing WhatsApp or any other social media platform to share any information or private data of any user of these platforms to any global agencies for, and they have to be really clear to find out, to take an undertaking that these information is not being used by such platforms for monetization. That's what Anisha has really pointed out. It's big important information coming in there. And of course, 9th Feb is when Supreme Court has is going to be hearing the cross appeals by Meta, WhatsApp, and CCI against the NCLAT order on Feb 9, right there. So thank you so much, Anisha, for giving us all of those details there.